Hello everyone, Jackie Jones, and this lecture is number 4 about the client interview. So far you're at the stage where you've studied law, both your core and elective, and you're now in the stage of transition from your knowledge of the law from studies to skill application, and that's the purpose of practical legal training, is to bring that practical aspect into all that legal knowledge, bringing the skills to the client, how you can deal with all that legal knowledge in a positive, constructive way. So this part 1 of lecture 4 is going to be about the interview assessment, as well as looking at the foundations of what a client interview is all about. Now, some of you who are listening to the lecture may be working in a law firm and you may have observed client interviews. Some of you may be working in a non-legal environment but have seen or observed people being interviewed in the particular area where you're working. One thing about interviews is that it really is a matter of a personal style, and how you start out interviewing clients may change as you become more confident, as your skill base broadens, and you develop as a person. So certainly, as the way that I interview a client now is very different to how I interviewed a client over 30 years ago when I started in practice. But it is a skill that we need to understand and think about how we're going to approach. Even if you're not going to be interviewing clients, you might be going to a tier 1 firm or a mid-size firm, and the interaction with clients is usually much more limited than if you, for example, going into the country or a suburban or a small city practice. It is still a people skill that is one that is essential for you to have an understanding and an appreciation of. So what is the client interview assessment all about? What does it involve? Well, you're going to be coming on the 9th of January 2016, and that's when the client interviews take place. There will be times allocated, and the subject coordinator, Daniel, will be preparing a timetable for the client interviews, which will allocate you to a particular room and a particular time, and it will also allocate you a particular matter that you will be involved with. Now, after that client interview, you then need to draft a letter to the client. Now, that letter is based on the interview that has been conducted, and the due date for that letter is 5 p.m. on the 15th of January. Now, it's very important, and I think I've said this in previous recordings, it is not a letter of legal advice. It is a letter based on the interview you've conducted, and the interview is all about listening and gathering facts. Go back to those lectures on effective communication, problem solving, and how we need to expand the information that we're given. So a little bit more information on the interview assessment. First of all, professional dress is required. So you're going to act like a lawyer, you're going to look like a lawyer, and you're going to feel like a lawyer, fingers crossed. Now, with that scenario, if you have an issue, please contact Daniel about what the appropriate dress code is. But just by way of a guide, gentlemen should be wearing a suit with a shirt buttoned up at the neck and a tie, as if you were going to the Supreme Court of New South Wales. And females should have likewise clothing that is as if you were going to be appearing in the Supreme Court of New South Wales. The bar can't be too high. So no inappropriately short skirts. You should be wearing a jacket with either a skirt or a dress or trousers, and that it be, as I said, appropriate. If you have any query about that, please drop me an email, but I do have a link that might be appropriate for you to have a look at there on the screen slide. Okay, so there's going to be a draft timetable placed online. Check your room and your time very carefully. If that time doesn't suit, and we do our best to coordinate the times with those convenient to students, but if not, then you'll need to organise with another student, and both students will need to confirm that change with Daniel so that the appropriate amendment can be made to the timetable. So it's basically 1 hour that you will need to attend UTS on the 8th of January. And the scenario is this, that for the first half an hour, you will be either the solicitor conducting the interview, or you will be the person who is acting as the client, and you then swap roles with your fellow student. So as an example, I am going to be the student who is going to conduct the interview as the solicitor for the first time. So I will be in the room for the 30-minute period. For the first 5 minutes, my fellow student who is the client will be given confidential facts to read. Now, they're not provided prior to the 8th of January. They're not provided prior to your interview time. They're provided at the commencement of the interview. The student who is going to be the solicitor just takes that 5 minutes to get into the zone, so to speak, get your thought processes before you start the interview. There is then 20 minutes for the interview, and a 5-minute warning will be given after 15 minutes. So at the 15-minute mark, you'll just be told 5 minutes. That means you've got 5 minutes left. Now, at the end of the 20 minutes, time will be called and it's not extended. As you can appreciate, there's a very short time frame that we need to get through a number of students. Now, the student who is the client will then leave the room, and the assessor and the student who has been the solicitor will then have a 5-minute feedback session as to what went well, areas of improvement, so that it's there, it's on the spot, and the student can then address any concerns that they had. Now, once that student has completed that 30-minute in their role as the lawyer, they then change and become the client for their fellow students. So it's just 1 hour that you'll need to be here at UTS on the 8th of January. Just a little bit more. When you are in the role, you are only assessed in your capacity as the solicitor. You're not assessed in your role as the client. So one of the best tips I can give you as students is take a highlighter to the interview, because when you get your confidential facts, you can use that highlighter just to highlight important points that you will and can refer to during the interview. Now, the confidential facts are used by the student who is the client during the interview. It's not a memory test for the client. So you do have those confidential facts there, and you refer to them during the interview process. With the confidential facts, one side of the paper has information that you as the client can provide to the solicitor without issue. The other side of the page is information that is only to be disclosed upon questioning from the solicitor, so the real confidential facts. Now again, slide 7, it is not a test of your legal knowledge. It is all about listening, using questioning techniques to expand or to unpack the information given to you by the client, to develop an understanding of the client's perception of the problem. Now, it's not one that is just restating to the client what the client has said, but really trying to understand what it is that the client wants to happen and what their concerns are. For example, I'm going to be talking in this lecture about questioning techniques, and there are also resources online to assist you in that regard. So just bear in mind, and that it's not, please, big flashing lights, it's not a test of your legal knowledge. Then the letter to the client, it's to be addressed correctly, plain language, confirm the instructions you've obtained in the interview, make sure you're aware of the due date because penalties do apply. Now, when it's got there's no more than 1,000 words, you don't need to use all those words. It might be that the letter is relatively brief because it's not a letter of advice, and the letter is based on the interview. Please don't think that you need to go and source information from friends as to what they acquired by way of information from the interview, because the assessors keep a record of all the information that students obtain in their capacity as solicitor, and that is then used as the reference point for the letter. So when we're thinking about the application of skills, it is very important to just reflect on what we've talked about previously with the problem-solving methods of gathering those facts as part of the client interview. And to do that, that is coupled with your active listening and your questioning technique skills. So all building up or scaffolding for understanding the client's concerns and needs and what they're wanting to achieve. The purpose of a client interview is first of all to start and forge that relationship with the client, the beginning of a working relationship, the need to develop trust in each other for them to be able to feel confident that you're going to be able to represent them and to assist them in dealing with their legal issue. So that's step one, building rapport. Putting them at ease so that they in fact do talk and do provide you with information, because the second limb or the purpose is that fact-finding exercise, enabling lawyers to get that overview of facts, to unpack all the information that the client has told you about, albeit it might be in an abridged form. Just think of this when you go and see a professional, someone who you may not have been to before, never had anything to do with or anything associated with that particular industry. That's what it's like when clients come to see us as lawyers. We might, notwithstanding we're very nice people, of course, but the client might feel intimidated for all sorts of reasons. You need to reassure the client about confidentiality, and that links back into one of your earlier workshops about the importance of confidentiality and what it means to put the client at ease that whatever they say during a client interview or tell us at various times will remain within the confidential framework of the relationship. It's also important to confirm the client details and obtain other details that may be necessary. Quite embarrassing for a client to come and sit and to meet with you, and then all of a sudden you realise you don't have their mobile number or their email address, or what's the best contact detail for them. So again, that's all part of a structure as to going through a process of putting a client at ease and obtaining information from them of relating to them, and then of course the relevant facts. We have an obligation on costs to make a disclosure to the client, and again that should be part of putting the client at ease. Is the first consultation free? For your client interview assessment, it is. So tell the client that this consultation is free. If we undertake work on your behalf, our fees will be, and that's going to be in the information facts that you will get for your client interview assessment. Try to understand the legal and the non-legal issues that the client is bringing to you as the professional, and going through that process of what it is we need to achieve for that client. It is very rare that in a first interview with a client you are going to have enough information and facts to be able to provide legal advice. And it is for this very reason that your client interview assessment is not a legal knowledge test. Bearing in mind that clients will have a different focus of a client interview to that of the lawyer. The lawyer is wanting to obtain relevant information, to in effect control the interview, having regard to the communication style of the clients, where the client focus is often that the lawyer will share their view of the situation, that they will provide available options and to help solve the problem. But importantly, don't forget that the client's focus will also be what it's going to cost them. What are the legal fees? So again, that is not only our obligation under the rules, but it is part and parcel of forging that good relationship with the client. Why do we need to interview well? Why do we need to go through this process? Well, it really is all about maintaining good clients. Happy clients will then be a source of referral, which is good for business. It's a function of a lawyer to be an effective communicator. We don't want complaints. We don't want to have to deal with correspondence from the Legal Services Commissioner. We want to act in a professional capacity and in the best interests of that client, bearing in mind the duties that we have to the court and to the client. The engagement management issues are important and need to be addressed, and you can find those in the Learning and Reading Guide as well as other resources that are online. But importantly, don't ignore the non-legal issues that inevitably are part of a client's problem, whether they may be family, whether it might be reputation if it's a business associated issue, financial, or how is it impacting on a client's financial situation. There may be mental health issues. Many aspects can impact on how clients are going to deal with the problem. So ultimately, we want to interview well so that we avoid problems arising. And if we don't devote enough time to our initial interview, to establishing that relationship, to defining the retainer, what it is that the client is coming to us as lawyers, as professionals, for us to do. What are we being retained to do? What are the services we are to provide? To unpack the information and to obtain more details as to what it is that the client is concerned about, and importantly, to speak effectively, clearly and concisely so that the client understands what is then going to occur. And we will then confirm advice in letters and file notes, which of course is a risk management aspect of our client interview scenario. Now that's the end of Module 1 of this lecture. Thank you.